Now I'll try it again. Good, oh, wow, look at that. Good morning. We're pleased to be here today at Arizona State University, Sandra Day O'Connor College of Law. It's always a pleasure to go on the road, but particularly when we're arguing primarily before law students. It's such a great opportunity for you to kind of see real-world cases being decided, and we have two very interesting ones today. So our first one, we're here for oral argument on State of Arizona versus Eduardo Serrato III. It's our number CR-24-0264. As you know, each side has 20 minutes for your argument. Mr. Winger, you may keep whichever time you wish for rebuttal, but you have to keep your time yourself. Before we begin, I'd like to also announce that we have a new justice who you'll meet later, Justice Mary Elena Cruz, but she is recused in this case and the next case. And so we have with us in her stead today, former Chief Justice Rebecca White Birch, and thank you very much for sitting in for us as always. So with that, Mr. Winger, please begin.
Honorable Justices, good morning. May it please the Court, my name is Chad Winger, and I represent Eduardo Serrato III, the appellant in this matter. Criminal statutes must be read in context with their place in the statutory scheme, and that scheme's focus, giving force to all statutes involved. Statutes related to the statute at issue here today, ARS 1317-04, that scheme clearly distinguishes between an arsonist and those who are endangered by the arson as occupiers of the structure. When
Counsel,
you look,
may I please interrupt you and ask one clarifying question? When I looked at the supplemental briefing before the Court of Appeals, it seemed that the emphasis then, so I want to clarify the emphasis here, is that the defendant in this case could not be the person referred to in the statute, that there must be somebody else who is present in order to violate it. If that's true, then did you effectively concede that there was evidence that the defendant otherwise was so near as to be an equivalent danger?
well, I don't think that that was expressly briefed. I don't think that was the question before the Court of Appeals. I do think that the jury's verdict indicates that that was what the jury determined. I'm not conceding that he was so close because there was no evidence regarding the circumstances of the fire.
Well, and that's why I'm asking that question, because, obviously being present in order to violate the statute, if the defendant could be a person to violate the statute, then I didn't see anything in the Court of Appeals opinion that addressed the other part of the statute for violating it, that he was present and so near as to be an equivalent danger. Is that something we can take into account on this review?
Well, I would hope that you would take that into account on this review.
Because you seem to have clarified it a bit for me that the whole argument up to this point was just whether or not the defendant could be a person, as understood in the statute, to violate it if they were the only one present. Correct. Do I understand that correctly?
Yeah. So I think the implication of the argument is that the appellant in this matter, according to the jury's verdict, was present at the time of the fire. I think the implication of the evidence, or what the jury decided, was that if it was started with the fire was started in a truck with gasoline, and that it had to have been lit by someone, that someone leaning into that vehicle would have been present. I think that's the implication of the jury's verdict.
And so
did the state make that argument in its closing argument to the jury?
Well, in the closing argument, the state made the argument that it can be implied that Mr. Serrato was so near as to endanger himself.
So, what do you make of the second sentence of 131701, talking about an occupied structure? It says, any structure defined in paragraph 4 in which one or more human beings either is or is likely to be present or so near as to be an equivalent danger at the time the fire or explosion occurs. But then there's a second sentence dealing with dwelling houses that says, the term includes any dwelling house, whether occupied, unoccupied, or vacant. What does it mean that the legislature chose to say that an occupied structure is an unoccupied or vacant house, but they didn't say that with regard to any other kind of structure.
So in using the term dwelling house, that goes back to the common law. That is the nature of the common law offense of arson, that being that it was designed to protect others and the safety of their dwelling house. Now, again, as was set forth in the law review article stated by the state or cited by the state in their brief, there has been a metamorphosis of the law of arson. However, I do make two contentions, and that is we have to look at the use of the word arson in the statute. A person commits arson in light of what that meant under the common law, because that's how you read the plain language of that word. I also think that by using the term dwelling house, the legislature is pointing us to the common law to try and understand this statutory scheme.
So I think that's my point. Is it significant to you that they chose to carve out a dwelling house as still being an occupied structure, even if it's not in fact occupied, but they didn't name any other kind of structure, like a pickup truck?
Correct. And I think the statutes in defining structure have greatly expanded what a structure is from what it was under the common law. But I do think that that is a key sentence in the statute at issue. And of course, that defines structure in both ARS 13-1703 and a structure in ARS 13-1704.
Turning to 1704, the Court of Appeals really just took the language at its face. It does say a person commits arson of an occupied structure by knowingly or unlawfully damage it by causing a fire. And going to the statute that Justice Birch was just mentioning, occupied structure would include a vehicle that a human being was near. So as you said, your client is obviously a human being. So it strikes me that the Court of Appeals was on pretty good footing, saying, well, it's the plain language. You mentioned it's absurd, though, and I was thinking that through. Is this really simply a policy decision by the legislature that we should leave to the legislature? Perhaps they don't wish to have even the arsonist nearby. They would like to punish that more severely because that might put rescue personnel, for example, at risk for their lives if they have to show up and rescue the person, even if it's the arsonist. So what do you think? Why shouldn't we leave this to the legislature to correct?
Well, Chief Justice Timmer, I think, again, if you want to read the words one or more human beings in isolation, I would agree that you're correct, but also I think we're ignoring the unoccupied structure crime in the statutory scheme, and I don't think that that's reading it in context. As I mentioned in my briefing, I think if you could very easily look at the plain language of these statutes and say that the legislature made a distinction between the arsonist and the occupiers of the structure. The statute on its plain face, both 1703 and 1704, say that the perpetrator of arson is, quote, a person. And then when you get to the definition of occupied structure, they don't use that term again to refer to the arsonist. And a person could include the arsonist and everyone. But they chose to use a distinct term, one or more human beings. And I think that you can read the statute and look at it and say that, the legislature believes that its language is distinguishing between the arsonist and the occupier of the structure. I also found it noteworthy that in ARS 1-215, when some of the statutory definitions, that statute implies that the legislature uses the term person to refer to a perpetrator of a crime. And so I think that that's applicable here, that, of course, if you read in isolation, I think it's a no-brainer. One or more human beings includes anyone.
Can we consider the tiered nature of punishment under the arson statutory scheme?
Well, I think that that's certainly, there are only two distinctions between ARS 13-1703 and 1704. The one is that 1704 adds the word occupied, and that's the only difference in the statutory language. And again, the punishments for each offense are tiered. Arson of an occupied structure is graded higher. It's a class 2 felony. Arson of a structure unoccupied, or yeah, a structure unoccupied is a class 4 or lower. And so I think this is what my argument was in my supplemental briefing in the Court of Appeals, and that is when you look at the dangerous nature of fire, that it is, it's been determined in other case law that that is a dangerous instrument, and that can result in enhanced penalties. Now, of course, these are sentencing enhancements for dangerous crimes, but I think you have to look at the enhancements and say, what is the legislature trying to accomplish here? What is the focus of these statutes? And the focus would be we aggravate the penalty for endangering other persons.
Mr. Winger, the biggest problem that I have with your argument is the statutory history. As you acknowledge in your brief, the original proposal made this distinction that an arsonist is not a person or a human being for purposes of the occupied structure aspect. But the legislature rejected that. Our rules of statutory interpretation focus on the words the legislature chose to use. But these are words the legislature chose not to use. So wouldn't we, if we follow your argument, wouldn't we be essentially writing those words into the statute, the very words that the legislature chose not to include in the statute?
Justice Pollock, I find the legislative history in this case quite interesting. And I'm sure, as all the justices know, when the legislature was going through an adoption of the Model Penal Code in 1977, that was quite a legislative session, and there's quite a lot of legislative history there. In that legislative history, as a matter of fact, in preparing for this oral argument, I went back and I looked at it, and it did go through a couple of versions. I believe that the initial language that was in there was trying to exclude from the occupier the perpetrator of the crime. And then that was later changed. And I find the second change somewhat interesting. I think it's almost can be read that the legislature objected or rejected language that says that the perpetrator could be the occupier of the structure. And the reason for that is they said, except for the, and I'm sorry, I'm not quoting it directly, but the gist is, except for the perpetrator of the crime, unless unless the perpetrator is the owner or occupier. So that was added at one point. That was what went to the floor initially and then was amended. But I looked at that and I said, it seems to me like they're saying that the arsonist could be the occupier in this version, and they rejected that version. So at best, I find the legislative history bewildering. And also what I can say is I pored over the legislative history of the statute, and I could not find anything that indicated to me the rationale, the reasoning for those changes. There were no discussions. I couldn't find any record, transcripts, recordings, anything of that nature. So I think it's a mystery as to what the legislature was thinking, but I do find it somewhat bewildering that at one point they had a version of the statute that seemed to indicate that we're going to exclude the perpetrator, however, unless they're the occupier. So it seems as if perhaps the legislature may have rejected an understanding of the statute that's in the Court of Appeals opinion.
Is there anything in the legislative history that suggests that the legislature contemplated or intended to limit Section 131703 to circumstances in which the arsonist places an explosive or fire-generating device remotely?
I did not see anything like that in that legislative history. And again, part of my absurdity argument is, if we're going to enhance, look, I think it's tough to argue that almost all arson, the arsonist is going to be in, near, or in the zone of danger for an arson. And when you look at the annotations to the statutes in the Arizona Revised Statutes, you look at the annotation, I didn't see a single reported case, or I really couldn't find even a case where we're talking about a remote setting a ticking time bomb, lighting a long distance fuse, shooting a fiery longbow, or even a Molotov cocktail. But when you think about those practically, those types of acts, those are very dangerous acts. And it strains credulity in my mind that the legislature would not enhance those kinds of crimes, or would even set up a lower graded offense that could only occur under those extraordinary dangerous circumstances.
One of the things Justice Bullock was asking about legislative history, we don't get to legislative history, of course, unless the language is ambiguous. Is your, and I can't recall your argument in the brief on this, is it that there's an ambiguity in the statute which causes us to look at secondary principles like the legislative history, or is it your argument that read in context with the other arson statutes that this is plain on its face?
Well, I think it could be one of two ways. I think when you look at the legislature purposely distinguishing between a person and one or more human beings in the statutes, that could be, I mean, you have to take into account that the legislature used different terms there. But what I would say is I think there's certainly ambiguity because the state has, I think, a reasonable argument as to how you would read the statutes, and I have a different reasonable argument. So I think that gets us to ambiguity. And of course, I think we're here before the Arizona Supreme Court, so a lot of times I think there must be something here. Are there any other questions? If no other questions, I'll reserve the remainder of my time. Thank you.
Okay, Ms. Jones. And you might mention, is this ambiguous or plain in context?
I haven't even introduced myself.
Good morning. I got to get my question in before I can.
May it please the court, Alice Jones on behalf of the state of Arizona. And I believe your question right out the gate is it plain or ambiguous? I think we're here on a plain language reading, and I will agree, I don't think the legislative history comes to play unless this court were to find ambiguity. But on the plain language, the legislature chose broad language that includes a participant of the crime. And the broad language is really exemplified by the fact that 2 of the 3 ways for a structure to be occupied does not even require a person to be inside. I recognize the second sentence you were asking about, Justice Birch, talks about all dwellings, basically all dwellings, whether they're occupied or vacant, but the remaining structures, there's still 2 ways to commit arson of an occupied structure without physically being inside of the structure. I think it's important here that Mr. Serrato is not arguing that the legislature exceeded their authority, that this broad reading is unconstitutional, or they were without the power to define it this broadly. Instead, it just turns on kind of the policy decision of the legislature and asking this court to add language in the statute that really is not there.
But what about the fact that, sorry, 1704 uses the word a person, and there's different terminology used in the occupied structure definition, one or more human beings. Is that a distinction without a difference?
I believe so, because person is statutorily defined in 13105, and the first definition is a human being. So I do think person and human being are synonymous in the statutory code.
I have a concern that arson generally is a class 4 felony, but arson of an occupied structure is a class 2 felony, which is very, very serious. It's up there with second-degree murder. In this case, for example, Mr. Serrato was sentenced to 25 years for second-degree murder and was given credit for almost 4 years' time served. So 25 years for murder and 35 years for the arson of the truck with no credit for time served. I find that troublesome. Now, I know it's not the facts of this case, but assume for the moment that he singed the front seat. But he was nearby when he did it. He held the match there and tried to get it to catch fire, and it really wouldn't. But it's arson of a truck. Is that really worthy of being a class 2 felony with a more serious penalty than a murder?
I understand, and I have a couple answers to that. First, I I think that the legislature drew a distinction here between harm to persons and harm to property. And when someone is near, it's not just being near, it's near to be in the equivalent danger at the time the fire or explosion occurs. And so if someone is putting a match in a vehicle and just singes the vehicle, and there's really not a lot of damage or danger, I think it would be really hard for the jury to find that they were in the equivalent danger when the fire occurs as being inside of the vehicle. Here, on these facts, there was accelerant in the vehicle, a gasoline can on the passenger seat, and it was a pretty big fire. The whole entire interior is burned, and when he arrived home, I believe he said to his sister's niece, who he was living with, or she smelled an overwhelming smell of gasoline. That is very dangerous. I think the common understanding is if you are around a large amount of gasoline and light it on fire, you are in a lot of danger yourself of getting harmed in that situation. And so I do think in this situation, there's evidence of danger to him. But that still would be a jury finding and still be something that it's not just merely being near the fire being set.
What purpose does Section 13703 serve in light of this interpretation of the statute? Because it seems to me, just as a matter of logic, that any arsonist who's present as they set a structure or property ablaze basically morphs a 13703 violation into a 1704 violation. So what purpose other than a remote ignition device would 1703 ever qualify upon which to prosecute someone?
Well, I think there's a few ways, Your Honor. Again, being near is not enough. So in the situations where it would almost be a lesser included offense if there's a jury question of whether they were so near as to be in the equivalent danger. I do think there are, even though I think the class, I'll admit the class of occupied structure arson is much broader than arson of structure under 1703, there are ways to remotely commit arson. There's remote detonating devices. I can think of someone driving by somewhere and throwing a Molotov cocktail or something into a structure. I think there are different fact sets that we can think about where it would still come into play. And I think that's particularly a policy choice of the legislature to make of what the distinction between arson and arson of a structure and arson of an occupied structure by the words that they use.
I'd like to return to the statutory history. This court has made a distinction between legislative history, which is what the legislators say, or reports, or that sort of thing, which are definitely a secondary interpretation device, and statutory history. That is, has a statute been amended? If so, what are the changes and why are, what is the meaning? Does the statute divert from a model bill? And in this instance, what I would call statutory sequencing, which is how did the bill itself evolve, which I personally think is a much more reliable and perhaps a primary device rather than a secondary device. But in any event, here, Mr. Winger has said that the two prior versions that the legislature did not adopt, one cuts one way and the second one cuts the other way. What's your comment on that?
So I agree with his comments. I've looked at the history too, and I find myself in the same position as Mr. Winger.
So do I. That's why I'm asking you about it.
Okay. So I have the language in front of me that I think was the original that had both parts with one or more human beings other than a participant in the crime unless such participant is the owner or occupant of the structure. So I think under that version, they recognized they were excluding a defendant, but then had an exception for the exception that if the defendant is in the owner or the occupant of the structure, they would still be committing arson of an occupied structure. Then I think that was struck, and then it was other than a participant of the crime, excluding a participant of the crime, and then the language we have finally appeared. And so I really do think both show that they know how to exclude a defendant. And when you couple that with other statutes in our criminal code that make it clear another person, I mean, there's examples all throughout the criminal code when the legislature intends to exclude a defendant, they say another person. Even within Chapter 17 with the 1706 that we cited in the briefing for reckless burning of wildland, or I think it's intentional knowing reckless, negligent burning of wildland other than a person's own. So I just think that that shows, again, that the legislature knows the words to use to exclude a defendant and did not do so here. And I think, even if this makes it unique, arson is its own unique crime that poses a danger to the public. Fires, especially in Arizona, can quickly get really out of control. And so I just think that the legislature here drew a line between harm to persons and harms to property, and it was the choice of the language used whether to include the defendant in that.
So would the defendant be his own victim then?
I don't believe so. I don't think that would qualify. I think we're looking at the scope of the crime. And I find that Tennessee case to be helpful that we cited that talks about why by using the defendant as a person who could be the victim of or not victim, again, I don't want to say victim, but hurt by the fire. It's just a policy decision by the legislature, and one that, again, it increases the danger or the risk of the fire.
But didn't that Tennessee statute include first responders
It
as
did.
covered by the statute, unlike this statute? It expressly considered the welfare and safety of first responders in the text of the statute.
Correct. And we do, I know we have a statute about costs to first responders. So if you light an arson, I forget the statutory reference, but it's within Chapter 17, we do award costs to personnel that have to respond to a fire.
Well, and to button up the point too, a defendant in an arson wouldn't satisfy the constitutional or statutory definition of a victim because they would be the accused.
Correct. And there are other statutes, driving under the influence, that can bring harm to a defendant themselves, but that doesn't necessarily render them a victim under that statute.
Your opposing counsel mentioned that it is very rare for these remote devices to be used. It's a very, very rare set of circumstances, and therefore, that lends itself towards absurdity. It strikes me that if something is an extremely rare set of circumstances, that does sort of along the spectrum move towards the absurdity. How do you respond to that?
It's a tough line to draw of when something reaches the line of absurdity. I think it has to rise to something, some of the language that you see used, I think like Scalia and Garner, no reasonable person could intend. And I do think one of the amicus briefs kind of highlights that with State versus Estrada, where you have a proposition that was passed to mandate probation for first and second time drug offenders, but didn't think about drug paraphernalia. And with the broad definition of drug paraphernalia, I can't really think of how you possess or use a drug without also possessing drug paraphernalia. I think it's impossible to do that. Here, it's a smaller class of crimes, but it's not impossible. And again, being near the structure doesn't automatically mean that it's arson of an occupied structure. There's still more of a jury finding that must happen there, that they are in equivalent danger. So I don't think it's impossible to commit arson of a structure like it would be. And I think Estrada is a great example of really when it rises to the level of absurdity.
I had clerks pull the evidence that the defendant was in or near, and it's really almost non-existent. And then I looked at the prosecutor's closing argument. There really is no argument on this issue. The prosecutor simply says it's obvious he was near, which is, of course, not evidence. Would you address that point?
Sure. I have a couple responses. I will say the court issued a MEM decision with the opinion, and they addressed kind of the statutory construction part in the opinion and sufficiency in the MEM decision. And I don't think sufficiency is in front of this court. But I will say it was very briefly mentioned. Again, this was a murder case. And so I think a lot of the focus was on and a denial of committing murder and what evidence put him at the scene. I think the testimony that came in, and it was a statement, I believe there was impeachment by the statement of the niece that smelled the overwhelming smell of gasoline, is really what puts him at the scene, because first responders that came to the scene of the fire for the pickup truck smelled overwhelming gasoline, and there's gasoline accelerant inside the cab of the truck. And so I think that puts him at or near, and then they can use their common knowledge to determine, and it's kind of common understanding of near to be in the equivalent danger at the time the fire or explosion occurs.
Okay, so I'm like a TV movie watcher, and they're always like smoking the cigarette, and then they throw the cigarette. Is that sufficiently close?
Well, they have to find knowingly. So I think they have to be, you would have to knowingly, I threw the definition in here, that you're aware and believes that the person's conduct of such a nature that the circumstances exist. So I think reckless and negligent versus knowingly might address that situation of when someone's just really reckless with a cigarette.
Let me follow up on that, though. Isn't one way to make a distinction between 1703 and 1704, then along those lines, and some of the circumstances that we have here, to really hone in on whether or not someone is so near as to be an equivalent danger? I mean, so near to almost be as if you were in.
Correct.
And to Justice Birch's point, the evidence is pretty thin there, but as has been made clear, that's not in front of us.
It is. I think it's tricky because there are no eyewitnesses. So yes, it's a circumstantial evidence case.
If earlier you had mentioned that 1703 is a lesser of 1704, if we ended up agreeing with the defense here and read it the opposite way of the Court of Appeals, what should we do with that? Do we simply vacate the conviction and send it back for resentencing without that conviction, or send it back for an opportunity for a new trial on the lesser, I guess, if you charge the greater?
I think that this court, within that finding is the finding of the lesser. So I think this court could, and again, we would believe the court should affirm the convictions as is. But in that scenario, I think that you would remand for resentencing on the lesser. I think that court has within its power to reduce it to the lesser under 403(6) or 7 off the top of my head. And I think that would be the remedy. If there are no further questions, I ask this court to affirm the Court of Appeals decision and the conviction and sentence in this case. Thank you.
Thank you, Ms. Jones. Mr. Winger.
I just wanted to conclude on the concept of ARS 13101 and the idea of fair warning. And this statute was passed nearly 50 years ago. And going through all the annotations in the statutes for 1704 and 1703, I think what you find, what you find is in 1704, the reported cases are horrific arsons where children are trapped inside of houses. Victims of crime are left in house, and then, in fact, the state, in its own brief, cited State versus Newfield. And if you look at that case, it is the identical factual scenario to this case, where the defendant Newfield leaned into a vehicle and started a fire, and that is reported as an annotation to 1703. He was charged with arson of a structure, not arson of an occupied structure. It's an identical factual scenario. And I guess my point would be, in terms of fair warning, over the last 50 years, I think that what the legal history of the statutes of arson reveal is that these cases have been handled and viewed by charging prosecutors the way that I am viewing these statutes. And we are 50 years into this, and I just I would just submit that charging of arson under ARS 13-1703, if the Court of Appeals is upheld, will almost disappear, according to the 50-year history of the law of arson.
Counsel,
in
let
the
me press
state.
that point just a bit, though, because isn't it a prosecutorial discretion issue whether to charge 1703 or 1704? And it could be, based on evidence, as we've been discussing here just this morning. I don't know, maybe if he had changed shirts and there wasn't an odor of gasoline, there couldn't be an argument that he was so near as to being an equivalent danger, in which case you very well could have cases that would support a 1704 charge, but the vast majority may not.
Fair point, Justice Montgomery. And I guess what I would say is my point is, if you look at all of the case law, I think all of the case law reflects that these statutes have been viewed as arson of an occupied structure is an aggravated offense, not an aggravated offense, but a higher graded offense because it endangers other persons. And I guess that's my point is, we're supposed to read these statutes in order to give fair warning to all citizens. I think if you were to look at the two statutes, I think that's a fair reading of the two statutes. And again, I guess if you want to focus on reading in isolation one or more human beings, that can be done. But I don't think it works here because of the statutory scheme. And this statutory scheme is different from the statutes mentioned by the state, where the term, technical term, another person is used. Those are, I believe, endangerment. There was a terrorism statute that they mentioned, using bioweapons against another person. But what those crimes don't have that arson has is a distinction of trying to protect persons and trying to protect property. The statutory schemes there are very different. And then I did want to make a point about the Tennessee case that was.
Before doing that, I just want to make sure that you get a chance to answer the excellent question that Chief asked of Ms. Jones, which is, if you win, what do we do?
I think we would remand for a new trial. And I did want to make a point about the Tennessee case where, and I agree with Vice Chief Justice Lopez's point on that it was actually there were different elements to that crime. It was if someone is actually injured as part of the arson, and they held there that because the arsonist injured himself in the conduct of the arson, that he qualified under that statute. But that statute in the Tennessee case actually referred to the arsonist as a person and as the injured as a person. They used the same term, unlike in these statutes where the arsonist is noted as a person and the occupier is distinguished by use of the term human being. And then lastly, I would just note, and I put this in my briefs, California, New York very much aggravate or enhance arson when it's done remotely. And so I think that's indicative of my point that if the lower graded is going to be relegated to what it might be relegated to or is under the Court of Appeals opinion, that just doesn't make sense. So I ask the court to reverse the Court of Appeals and remand for a new trial. Thank you, Justices.
Thank you, Mr. Winger. I thank both counsel for their argument here today and for their briefs. Very helpful, very well done on both sides. And we will take the matter under advisement and issue a ruling in due course. So we will not stand adjourned. We're going to stay up here and stare at all of you while the next group comes forward.